Dog and rat feces ground into the flooring, carpets soaked in urine, chewed doors, destroyed skirting boards, ripped out wiring with bare cables exposed, furniture deliberately slashed. This is what enforcement officers were confronted with as they entered the cottage. The cost to the landlord, journalist Sally Jones, a bill exceeding £50,000 in damages, legal fees and unpaid rent. At first impression, Sally says there was little to suggest the scale of the problems that would later emerge. A car saleswoman. She wanted to rent our cottage and stables to keep a few horses and dogs. Initially all went well, though she occasionally forgot to pay her rent and utility bills, each time producing a moderately plausible hard luck story and repaying some of the shortfall in installments. Sally was caring for her husband with dementia and her elderly mother at the time, so she had little time or energy to chase her tenant too hard for money, and even reduced her rent during COVID. Within 2 years, Sally's mother had died and her husband was deteriorating. Speaking about the ordeal, Sally recalled, "That was when things took a terrible turn. The woman's 2 dogs became 6, then a dozen, and then several litters of puppies, until by the autumn of 2024, she was keeping 30 in squalid conditions. They whined and barked deafeningly in stinking cages on the stable yard and in the cottage itself, next to the room where John was now bedbound. When I begged her to reduce the numbers, she simply ignored my objections and even refused us access to do the annual landlord checks on the cottage," Sally explained. "That was when this stopped being simply a difficult tenancy. In law, persistent barking, foul odours, or conditions affecting neighbouring occupiers can amount to a statutory nuisance. Under the Environmental Protection Act 1990, councils have powers and duties to investigate complaints like these. If a statutory nuisance is found, they can serve an abatement notice requiring the problem to stop. Ignoring that notice is a criminal offence, and in serious cases involving animal welfare concerns, authorities can seek powers to remove animals from the property." Sally Jones felt overwhelmed by it all, but reluctant to serve her tenant with a notice because of the cost of evicting her. "I hoped things would get better," she thought. "Is this really a story about landlords losing power?"
And I thought, I've got to bite the bullet and go to court now. She'd been told by the council to stay and not to come out.
For 20 years, Sally Jones had rented out the 3-bedroom cottage beside her Warwickshire farmhouse. A private landlord, no antisocial behaviour team, no in-house legal department, no housing officers, and no extra budget for legal costs, just a landlord managing a property alongside significant personal and family pressures. By her account, most tenants had been perfectly manageable, but this tenant was the exception. Despite making hundreds of pounds from horse liveries and dog grooming, she persistently missed rent payments. Several horses looked skeletal and dogs were left cooped up for hours without water. The RSPCA were notified, but they were fobbed off. In October 2024, the tenant convinced Sally to let her elderly parents stay in several rooms in her house, thinking this might help her tenant with her financial problems. Misguided, she agreed. By 2025, Sally's tenant owed her thousands in unpaid rent and utilities. She then stopped paying rent altogether. By this stage, Sally considered the legal route to be her only option. Where serious rent arrears build up, landlords can seek possession under Section 8 of the Housing Act 1988. Ground 8 is a mandatory ground. If the arrears threshold is met both when notice is served and again at the court hearing, the court must grant a possession order. There are also grounds 10 and 11, which cover rent arrears and persistent late payment, but those are discretionary, meaning the judge weighs the wider circumstances. For some landlords, arrears can become the strongest evidential route because rent schedules, statements, and payment history are often easier to prove than building a wider antisocial behaviour case. Sally decided at this point that she would need to evict the family legally using Section 8 route on rent arrears grounds. We are unsure of which rent arrears ground had been relied on. Section 8 doesn't just cover rent arrears. Ground 13 can be used where a tenant, or someone living at the property, allows serious deterioration through neglect, damage, or misuse. Ground 14 covers nuisance, antisocial behaviour, or conduct causing annoyance to neighbours. But unlike rent arrears ground 8, these are discretionary grounds. That means even if the landlord presents evidence, the court still has to decide whether possession is reasonable. And where there's no criminal conviction or formal enforcement action, mandatory grounds for nuisance, Ground 7A cannot be relied on. The alleged perpetrator may make a counter-argument disputing or defending the case brought against them. That's why critics of Section 21 abolition often argue that saying just use Section 8 oversimplifies the reality. Without rent arrears, Sally may have needed witness statements, complaint logs, environmental health evidence, inspection records, and a much more heavily evidenced antisocial behaviour case. The case took 6 months to get to court. The tenant was ordered to leave the property in 1 week and pay over £17,000 unpaid rent and legal cost to be paid within a fortnight. Sally recalled, "Our solicitor predicted, however, she, her parents and boyfriend sat tight and paid nothing, encouraged by Stratford District Council's Homeless Department, who offered no help in rehousing them. She became increasingly abusive, lighting a bonfire in our yard, which badly damaged a friend's horsebox and almost set the wooden stables alight. To speed up the eviction, I eventually bit the bullet and took the case, at considerable expense, from the county court to the High Court. Just days before the enforcement officers arrived in October, she piled 5 tons of filthy rubbish around the yard and fled to a nearby stable with her dogs and anything of value she and her associates could cram into their vehicles, having already moved some of her horses and ponies to nearby yards. The entire saga has cost us over £50,000 in unpaid rent, legal fees and repairs to the trashed cottage. She has never paid a penny of the £17,000 she was ordered to pay in court, nor the £10,000 off she later incurred from remaining in our property. My solicitor advised me that the cost of employing enforcement officers to try and seize any of her assets would dwarf any sums they might fetch." Sally commented, "Now I know that regular offenders like my tenant are well aware of their rights and how to avoid retribution, usually putting valuable possessions such as vehicles into someone else's name. Instead, we spent the money on restoring our cottage. Months on, it is finally repaired and restored. Kind friends and neighbours from our close-knit village, horrified at our nightmare experience, rallied round and donated good quality furniture. But I would not dream of renting it out again, especially now that landlords will have even less power under the government's new Renters' Rights Bill." Sally stated, "The reform has been billed as the biggest shake-up in the rental market in over 30 years. It promises better protections to tenants against exploitative landlords and unfairly hiked rents. But for decent landlords, it is a disaster. It will make it even harder to evict the tenants who behave like ours did, requiring at least 3 months rent arrears rather than the current 2, and a judge's subjective opinion that their behaviour has been sufficiently antisocial. This can be particularly problematic when neighbours, intimidated by violent tenants, are too scared to give evidence in court." What Sally Jones's case highlights is the pressure placed on private landlords when multiple tenancy breaches escalate at the same time. Private landlords dealing with complex possession cases are often managing far more than the legal process itself. Gathering evidence, documenting incidents, keeping records, chasing arrears, responding to complaints, and building a case that may eventually stand up in court, all while trying to manage the practical reality of an escalating tenancy situation. That takes time, organisation, and in some cases, emotional resilience. Particularly where the issues are prolonged, evidence-heavy, and becoming increasingly difficult to contain. What stood out in this case wasn't just the legal battle. It was Sally Jones' personal circumstances and the nature of the tenancy breaches. A landlord caring for a seriously ill husband, bereavement during that same period, the disruption of COVID, court backlogs, enforcement, and a situation at the property continuing to deteriorate. We often hear the lived experiences of tenants facing housing insecurity, and rightly so. But cases like Sally Jones's also highlight a perspective that is often less visible in what has become a deeply polarized conversation about landlord and tenant rights, responsibilities, and housing reform.